In this subunit, we're going to talk about the UCC approach to the statute of frauds. So we've already been through the common law statute of frauds. Let's now talk about the UCC statute of frauds. In this unit, we are going to look at UCC 2-201, which is the UCC statute of frauds. We're going to talk about what types of contracts are within the UCC statute of frauds. In other words, what types of contracts for the sale of goods require a writing. We will talk about what constitutes a sufficient writing under the UCC statute of frauds, just like we talked about when we talked about the common law statute of frauds. We're going to talk about the signature exception to the UCC statute of frauds, which the common law doesn't have. And then we're going to talk about when full or part performance under the contract for the sale of goods that's within the UCC statute of frauds will take the contract out of the statute of frauds or will act as a substitute for a writing. Let's take a look at the UCC statute of frauds found in section 2-201. All right, so our first question is, what contracts are within 2-201, right? What types of contracts for the sale of goods must be in writing? And the answer is contracts with a price of $500 or more, right? So the cutoff line is 500. Below that, an oral agreement is enforceable. Above that, it must be in writing. Now let's take a look at what constitutes a sufficient writing under the UCC statute of frauds. As we go through this, we'll compare it to our common law requirement for a sufficient writing. All right, so we know we need a writing, right? We go back to what we learned about the Uniform Electronic Transactions Act, and a writing, of course, can be an electronic record under the UCC also. The writing has to be sufficient to indicate that a contract for sale has been made. Similar requirement under the common law, sufficient to indicate a contract. And it has to be signed by the party against whom enforcement is sought, right? Same requirement under the common law. Must be signed by the party to be charged, right? Signed by the defendant generally. Remember, the Uniform Electronic Transactions Act, what we talked about, an electronic signature, would also apply here. All right, now this is a little bit different than the common law. Under UCC 2-201, it says a writing is not insufficient because it omits or incorrectly states a term agreed upon. Under the common law statute of frauds, a sufficient writing requires that it states the material terms with reasonable certainty. The UCC is a little bit more lenient, but it must state a quantity. It's only enforceable up to the quantity. So for example, imagine we have an oral agreement for 10,000 widgets. And then in our writing, we only have 5,000 widgets. The contract is only enforceable up to 5,000. All right, let's talk about the signature exception under the UCC statute of frauds. Remember, generally, for a writing to be sufficient under the common law statute of frauds or the UCC statute of frauds, it must be signed by the party to be charged. It must be signed by the defendant in our case. The UCC has a signature exception, and under this signature exception, the plaintiff's signature on the writing is sufficient. Let's go into the details. All right, there's 2-201. And the whole idea under 2-201 is that we have an oral contract between merchants. And one of the merchants sends a written confirmation of their oral contract. Let's go through the details. All right, so we know that the first requirement, the first element of our provision here is that the contract is between merchants. You remember what a merchant is? Right, we said our shorthand for that is someone who regularly deals in goods of the kind or holds herself out as having such knowledge. So we're looking for facts that indicate that both parties are merchants. We said that we're expecting under 2-201 sub 2 that we're going to have an oral contract between merchants where one party sends a written confirmation of the oral contract to the other party. Here, the written confirmation must be within a reasonable time. Now the question is, what is a reasonable time? Are we talking about a reasonable time after the parties entered into the agreement? Or are we talking about a reasonable time before performance is due under the contract? The UCC doesn't say. The comments are not clear about it. I've seen cases that talk about a reasonable time in the context of either situation. So look out for that. All right, a writing in confirmation of the contract. Once again, one party sends a written confirmation of the oral contract between the parties. The writing must be sufficient against the sender, the person sending, the merchant sending the written confirmation. What does it mean to be sufficient against the sender? Well, it has to meet the requirements of 2-201, right? It has to indicate a contract, it has to state the quantity, and it has to be signed by the party to be charged. But in this case, it has to be signed by the party who sent it. It has to be sent by the sender. Excuse me, it has to be signed by the sender. The party receiving it has reason to know of its contents. When will that come up? Well, when the party received it and doesn't open it. Right? If the party receives it and opens it, either opens the email or opens the snail mail and reads it, then the party knows of the contents. But what if the party doesn't open it? Well, do they have reason to know of its contents? Do they know that it is a confirmation from the other party of an oral agreement? All right, if between merchants, we have a written confirmation of an oral contract within a reasonable time, and it is sufficient against the party sending the written confirmation, and the party receiving it has reason to know of its contents, it satisfies the statute of frauds against the receiving party, even though the receiving party has not signed it. Okay. The receiving party, though, still has some time to object to the content. So if you're the receiving party and you receive a written confirmation that there's an oral contract and you say there was no oral contract, you can send an objection of its contents within 10 days. And if you send the objection of the contents within 10 days, then that writing is not good against you. That writing is not sufficient against you under the UCC Statute of Frauds. Let's talk about the policy underlying the signature exception to the UCC Statute of Frauds. So imagine we enter into an oral agreement, right? And I want to send a confirmation. It's good business practice to send a confirmation, a written confirmation of our oral agreement. Well, if I send this written confirmation, now I'm exposing myself to risk. What is the risk? Well, if I send this written confirmation, now you have a written contract that I have signed that you could use against me under the UCC Statute of Frauds. What do I have against you? Nothing. My written confirmation, I signed it, you didn't sign it. And therefore, if I sign a written confirmation and send it to you, I expose myself to liability, but I do not bind you in any way, right? Your oral contract binds you, but your oral promise is unenforceable under the UCC Statute of Frauds because it was for $500 or more. That is the risk I take when I send a written confirmation under the UCC? Well, UCC subsection 2, UCC 2-201 subsection 2 has the signature exception, and now it encourages me to send a written confirmation. If I send a written confirmation to you and I sign it and you don't respond within 10 days denying that we have a contract, then that written confirmation is good against you. Once again, the big proviso to this is that only if we are both merchants. All right, remember when we talked about the common law statute of frauds, we said there were certain exceptions for full or part performance, right? There were certain times where full or part performance under the statute of frauds would take the contract out of the statute of frauds. In other words, the contract would be enforceable even though it wasn't written. Well, UCC 2-201 sub 3 has exceptions to the statute of frauds for contracts where there is certain types of full or part performance. So in any one of these four situations, the contract will be enforceable without a writing, even though it is a contract for the sale of goods for $500 or more. The first exception is when the contract is for specially manufactured goods and the seller has taken a substantial step to manufacture them or procure those goods. The second one is where the defendant admits that there was a contract. The third one is where payment for the goods has been made and accepted, made by the buyer and accepted by the seller. And the fourth one is where goods have been delivered and accepted, where the seller has delivered the goods and the buyer has accepted those goods. We're going to talk about each of those briefly in turn. All right, let's look at the performance exceptions under the UCC statute of frauds. We're in UCC 2-201 sub 3, and the first one we're going to look at is sub A. This is the specially manufactured goods exception. Pause here, read through this provision, and see if you can spot the elements that you need to discuss or the elements that you need to look for facts that deal with these specific elements. Pause here. All right, did you pause? There they are, right? It has to be goods that are going to be specially manufactured for the buyer. They're not suitable for sale to others in the ordinary course of seller's business. There is something that reasonably indicates the goods are for the buyer, and the seller has either already made a substantial beginning to manufacture the goods, or if the seller is not manufacturing the goods itself, it has made commitments to get the goods for buyer. All right, once again, that is the specially manufactured goods exception. If the fact pattern meets these elements, then even though the contract is not in writing, it will be enforceable, either against the buyer or the seller. It's normally going to be enforceable against the buyer, but it would be enforceable against the seller too. All right, let's look at another one. This is under sub B. Pause here, see if you can spot the important elements. All right, this is a case where the defendant admits that there is a contract, right? Admits in his pleadings, testimony, or otherwise in court that a contract for sale was made. So pleadings, testimony, or otherwise in court, right? But it's only enforceable up to the quantity of goods admitted. All right, here's the interesting thing. This might be a little bit different than the common law. Under the common law, the idea was that you could go into court and plead and say, listen, even if I admit that there was an oral contract for whatever, it's not in writing and therefore not enforceable. And under the common law, theoretically, a court would say, yeah, even though you admit there's a contract, I'm not going to enforce it because the law requires the contract to be in writing. This seems to be, this UCC subsection 3B seems to change the common law. And I wonder how a court, now that we have the UCC and the UCC is so well accepted, and that the UCC has influenced the development of the common law, I wonder if a court would apply this in a common law statute of frauds case too. All right, let's move on to the next performance exception. Now we're going to look at 3C, and this is the payment exception. There's not a lot of elements here. You can just read it, pause it for a second, and read it. All right, so if we have an oral contract for the sale of goods, and the goods have been paid for, buyer has paid for the goods, then the contract is enforceable even though it's not in writing, right? But it would only be enforceable up to the payment. So if the parties had an oral contract for 10,000 widgets and a buyer has paid for 5,000 widgets, then the contract would only be enforceable for 5,000 widgets. Let's move on to the next exception. I'll call this one the delivery exception. So with respect to goods which have been received and accepted. So seller has delivered the goods, buyer has received the goods and accepted the goods. What does it mean to accept goods? Well, it simply means that you haven't rejected them. That's all it means. Later in the semester, we'll talk in more detail about what it means to accept goods, but effectively it means that you have not rejected the goods. All right, so once again, if buyer and seller had an oral contract for the sale of 10,000 widgets and seller has delivered 5,000 widgets and buyer has received and accepted those widgets, then the contract for the 5,000 widgets is enforceable even though the contract is not in writing. Well, those are the performance exceptions under the UCC.